freedoms and civil liberties. That is to say, does the Bill of Rights work? Is the Bill of Rights or are bills of rights effective in protecting individual liberties and individual freedoms? Or are other factors involved, such as the structure of government? What is it that allows us in this country to enjoy such fundamental freedoms? Is it our structure of our government, our culture, our history, our traditions, the diversity of our people? What is it, and what would it be in other countries? Other countries have bills of rights that contain very elegant sounding rights for citizens. The Bill of Rights of Cambodia provides that citizens are equal before the law and have the same rights, freedoms, and duties regardless of their sex, beliefs, and religion. Citizens have the right to choose a career appropriate to their abilities and society's needs. The state guarantees protection against the physical violation of an individual. These are just some interesting provisions in the Cambodian Bill of Rights. Citizens have freedom of speech, freedom of the press, and freedom of assembly. Citizens have the right to set up associations. Citizens have the right to denounce, complain, or lodge demands for compensation and damages resulting from illegal acts of the government. That's the Cambodian Constitution. Here's another one that sounds like a very good place. Citizens are equal before the law without discrimination because of sex, blood, language, social origin, and religion. Equal opportunities are guaranteed to all citizens according to the law. The dignity of man is safeguarded. It is inadmissible to cause any physical or psychological harm. That's the Constitution of Iraq. The Soviet Union Constitution, citizens of the USSR shall have the right to rest and leisure. That's something. That would be nice. Citizens of the USSR shall have the right to health protection. Citizens of the USSR shall have the right to material security in old age. Citizens of the USSR shall have the right to housing. Citizens of the USSR shall have the right to education, the right to benefit from the achievements of culture, and so forth. So you can see that throughout the world there are bills of rights, but it doesn't necessarily translate into the same thing that we have for understanding the protection of individual liberties in this country. We have a panel of distinguished and well-versed individuals to speak on this subject today, beginning on my left, Professor Thomas Merrill, who has taught constitutional, environmental, and administrative law at Northwestern Law School since 1981. From 1987 to 1990, he was Deputy Solicitor General of the United States. He is a graduate of Grinnell College and was a Rhodes Scholar at Oxford. He received his law degree at the University of Chicago. He clerked for Judge Bazelon on the D.C. Circuit and Justice Blackmun on the United States Supreme Court. To my immediate left is Professor John Baker. Professor Baker is a professor of law at Louisiana State University, where he teaches constitutional law, criminal law, federal courts, and jurisprudence. He is a graduate of the University of Dallas and the University of Michigan Law School. He clerked for Judge Kristen Berry at the Federal District Court in the Eastern District of Louisiana. He was an assistant district attorney in New Orleans and has served as a consultant on separation of powers to the White House, the Department of Justice, and the Senate Judiciary Committee. He has written and litigated and lectured extensively on constitutional law and Bill of Rights, and has lectured and consulted with numerous foreign governments on the United States Constitution. To my immediate right, Professor Easterbrook, Judge and Professor Easterbrook. Judge Easterbrook is a judge on the United States Court of Appeals for the Seventh Circuit. He also teaches law, presently constitutional law at the University of Chicago, where he has taught since 1978. He was an assistant and then Deputy Solicitor General of the United States between 1974 and 1979. He has been the editor of the Journal of Law and Economics, which I guess is appropriate for someone from Chicago, since 1982. He is a graduate of Swarthmore College and the University of Chicago Law School. To my far right, but only geographically, Professor Herman Schwartz, who's been a professor of law at American University in Washington, D.C. since 1982. He was previously a law professor at the State University of New York at Buffalo. He specializes in American constitutional law. He's a graduate of Harvard College and Harvard Law School. He's a consultant for the People of the American Way. He is the author of Packing the Courts, the Conservative Campaign to Rewrite the Constitution. He has lectured and consulted extensively recently on constitutional law with several European nations, including Czechoslovakia, Romania, and Bulgaria. So you can see that we have a very skilled and experienced panel with respect to the subject today, and we'll start with Professor Baker.
Thank you, Ted. I appreciate you warming up the audience with the readings from the different constitutions. The thrust of my argument will be that the Bill of Rights in this country has not been nearly as effective as is often claimed. I will begin by distinguishing between its effectiveness symbolically or politically versus its structural effectiveness. Symbolically and politically, it's been quite successful. In fact, I would say almost too successful in a certain sense. We know that Madison introduced the Bill of Rights, and he did so largely to quiet the fears of those who opposed the Constitution. As he said to Congress in introducing the Bill of Rights, the opponents of the Constitution were convinced that the Federalists wanted to deprive them of their liberty. So for reasons of prudence, and because he said the Bill of Rights would do nothing to damage the structure of the Constitution, he urged his colleagues to pass the Bill of Rights. We know also from Professor Herbert Storing, in his work on the Anti-Federalists, that the Anti-Federalists didn't really believe that a Bill of Rights would have a great deal of practical utility. They looked on it as primarily important for its instructive purposes. In any event, after passage of the Bill of Rights, we know that there was almost universal approbation for the new Constitution. It created and accomplished what Madison wanted, and that was more than majority support, but overwhelming consensus behind this new Constitution. So in that sense, it was certainly, and has been, continues to be very effective, but so effective that in the minds of many people, when you say the Constitution, they read only the Bill of Rights, and they forget that there's another part of this document that precedes it. And it is that document that structurally and otherwise does a lot of things to protect liberty. If you look at what the Anti-Federalists wanted, it was unclear exactly what they wanted, as Madison wrote in Federalist 43. Some wanted protections of individual rights, and others wanted protections of states' rights. If you look to the 10th Amendment, we certainly have to say that insofar as the Anti-Federalists wanted protections of states' rights, they didn't get much in the 10th Amendment. Whether it's John Marshall you're talking about, or whether you're talking about the modern court after Ussery, you certainly don't see the 10th Amendment doing anything to protect states' rights, and so it should be. The 10th Amendment was not designed to do anything that wasn't already in the structure of the Constitution. But when we look elsewhere, and I won't belabor this because others I'm sure will touch on it, the structural protections of federalism and separation of powers are certainly designed to protect liberty and keep it from being the thing that Professor Ackerman described last night, statism. Or in the terms that they used back then, they wanted to prevent a consolidated government. It was not consolidated, it was not statist because of federalism and separation of powers. But there are also non-structural protections, which I think the next panel will probably talk on, and that has to do with the problem of faction, something that all of the new democracies around the world are struggling with, and how to protect against the violence of faction discussed by Madison in Federalist number 10. But when we get beyond all these, and you look at the court itself, and people start talking about the effectiveness of the Bill of Rights, and they relate it to judicial review and talk about the two as if they're the same, they forget. The Federalist Papers both gave the classic argument in Federalist 78 for judicial review, written by Hamilton, but Hamilton then in Federalist 84 argued that the Bill of Rights was not only unnecessary, it was dangerous. Now, what is it that Hamilton expected the courts to do in protecting individual rights, as he mentioned in Federalist 78, if he said in Federalist 84 that the Bill of Rights was dangerous? Well, there are other rights besides those rights found in the Bill of Rights. And that's why we have the Ninth Amendment that says there are other rights other than in the Bill of Rights. One of the main arguments of the Federalists was the danger of a Bill of Rights is that if you list certain rights, it assumes that there are other rights that are not included. The other rights that they were primarily concerned with were both common law rights and statutory rights to be created by Congress. The real issue, I think, when it comes down to the Bill of Rights today is an issue of judicial review. It's not so much an issue of whether the court will articulate and discuss rights. The question is what may Congress do or not do after the court has spoken regarding a particular right. I think if we look to Congress, we will find that at least historically, the Congress is very much responsible, both in a positive and in a negative way, for some of the most important rights in this country. Last night, Professor Olson talked about state constitutions and the right to education, an affirmative right. But the fact of the matter is, the reason if you look in every state constitution that there is such a right goes back, as most of you know, to the Northwest Ordinance and Congress's provision for the Lands Act, which accompanies it and provided in all of the states, not for public schools, but for common schools. But the things that we often forget is that the Northwest Ordinance also did a couple of other things. It required that no state constitution would be allowed unless it was first of all approved by Congress. And what did Congress insist on in the Northwest Ordinance for every state? One, that they have a provision providing for freedom of religion. And the fact that we have freedom of religion in this country is largely due to the Northwest Ordinance in Congress, not to the courts, which did not intervene in the religion questions in the states until the late 40s. And we had freedom of religion, I think, before 1947. But the Northwest Ordinance also provided for, it was later, unfortunately, amended, and this court later ignored it. Dred Scott had provided for the prohibition of slavery in the new territories, and life in this country would have been a lot different if Congress adhered to that and had the court done something more about it. But we're not only talking about religion and talking about the issue of slavery. When we look to Congress, Congress did some negative things, certainly. And but in doing so, they also, I think, reinforced the view of the Federalist Papers. If you want to look at the First Amendment speech and press issue, we always start with the Alien and Sedition Acts. But the Alien and Sedition Acts were never declared unconstitutional because the Jeffersonians didn't want to test it in court. They didn't want to test it in court because they knew the Federalist Court would uphold it as constitutional. Indeed, Justice Story, writing in the commentaries on the Constitution, said there was never doubt in any of the minds of any of the justices on the court at the time that the Alien and Sedition Acts were completely constitutional. Now, that doesn't square with modern libertarian thought, but the solution was not by a court, the solution was political, and that is the Federalists lost, and they lost their party because they didn't pay attention to the injunction of the Federalist Papers. That is, that ultimately freedom of the press and freedom of speech were premised and would only be protected by public opinion, as the Jeffersonians in fact proved. But I would go further and say that the court itself has been responsible for the deprivation of liberty in a large area of importance in this country that is often not paid attention to. And that is in the area of police powers. The Federalists were concerned that any Bill of Rights would imply that the central government had powers that it actually did not have. And if you look at the 4th, 5th, 6th, and 8th Amendments, which deal so much with criminal matters, you would just automatically assume that the federal government had a police power. Yet, if there was anything that was agreed on by the Federalists and the Anti-Federalists, it was that the national government had no police power. And Hamilton said it over and over again. It was the court in 1895 that posited a police power that never existed before. Who today questions whether conservative or liberal, the appropriateness of the Congress enacting massive criminal legislation and enforcing a police power that has today been disconnected altogether from the commerce power? And yet, who says anything about it? But when you look at the Bill of Rights, you might imply that Congress has such powers. Now, what happened in the 1960s? In the 1960s and 70s, you certainly had an expansion of the 4th, 5th, and 6th Amendments in order to deal with questions relating to criminal procedure, to protect criminal defendants. Well, I don't know how good it is to be protected in a federal district court by all these protections if the statute under which you are being indicted, say a RICO statute, is subject to serious constitutional questions as to whether it is vague or whether it violates separation of powers in terms of its adequate definition of the statute by Congress. But that issue is never taken seriously. We worry about the Fourth, Fifth, and Sixth Amendments, but if you look at those amendments as construed by the court, what are we doing in the Fourth, Fifth, and Sixth Amendment? We are taking away from the jury many issues. We are, through exclusionary rules in the Fourth and Fifth Amendment, we are taking issues from the jury. But what was the most important right that both the Federalists and the Anti-Federalists agreed on? It was the right to jury trial. And the right to criminal jury trial was in the body of the Constitution long before the Bill of Rights. It was there. What have lawyers done with the right to criminal jury trial? From the beginning, the Supreme Court has cut back on the right to criminal jury trial by constantly shifting questions of fact into questions of law. And more recently, we have heard that jury trials are just too expensive and too time-consuming to indulge in. We have substituted efficiency for what was deemed to be the most important right. And that most important right of criminal jury trial exists in practice in very few cases. And yet, that was the school, jury trial, in which the colonists were first of all educated in the means of democracy that allowed them to govern themselves. And I would suggest that in many ways we have distorted it because we have exalted the role of judges over the other elements of government. The Bill of Rights is certainly important, but it is, as Justice Scalia says, the icing on the cake. This year is the birthday cake. Happy birthday.
Thank you, John. We will now hear from Professor Schwartz, and I hope that you will tell us a little bit, Professor Schwartz, about the advice that you've given to some of the countries that are now struggling to form a constitution, and perhaps you could tell us what you've told them about the importance of, or lack of importance of the Bill of Rights and protecting the freedoms that they seek to have in their country.
I think you exalt my role as an American in this process, or of any outside. Let me just respond to that for a moment. You know, there has been practically a shuttle of Americans and others, exactly like the New York, Washington, Boston thing, going to Prague, Budapest, Poland, and elsewhere. But the fact is that we have a very limited role. These are very strange countries. Churchill once said to Harriman, when Harriman was talking about English politics, "My God, Abel, you're talking about my politics. It takes a lifetime to learn your own. How can you comment on mine?" And this is where they had a common language, more or less separated. But there are language problems, different cultures, different histories. We come quite ignorant. One Bulgarian said to me, "I don't know where you would get off coming here. You probably don't even know where we are on the map." Our role is I think a useful one. In our own case, we make sure to involve West Europeans, Germans, French, Belgians, who have common backgrounds. These countries have been cut off from an enormous number of developments in the last 50 or 60 years. The communist lid really sort of almost took them bodily and turned them east. And since they don't have eyes in the back of their heads, except perhaps occasionally surreptitiously, when they sort of look around, much of what's happened really in the make almost of a constitutional revolution around the world in the last 50 years, one country after the other has created constitutions, is unknown to them. So what we do is we try to tell them what's happened elsewhere, what's worked in our own countries, what hasn't worked, occasionally to kibitz and make a comment here or there. Dick Howard and I actually put in a fairly intensive 3 or 4 days on the Czechoslovak Bill of Rights, following a conference that we had with about 12 or 15 of us on the Bill of Rights. And although I can find indications and traces of our influence, if one wants to exalt our role, the fact is that they have a pretty good idea of what they want. We helped in some respects. We alerted them to things. I've actually, in my report to the people who gave us some money, claimed, and I think with some justification, I'll mention some of these, sort of credit for influencing significantly about 4 or 5 important provisions, something to do with speech, something to do with right of access to information about the government, something about economic and social rights, a few other things like that. So I think we played a useful role, and they certainly welcome us. I think it's more than just our hard currency. But I would not exalt our role in this. To quote somebody, we're not Jewish, French, or German Thomas Jefferson. You got a little screwed up, you got James Madison. We're not that. We're not writing constitutions. We're helping a little bit. That's what it comes down to. In some areas, one can help a great deal more. Company law, commercial law, banking, constitutional law, and this sort of maybe get me to my sort of more or less prepared remarks. Constitutional law grows out of a nation's history. It reflects the nation's culture, and its aspirations, and its tragedies, and its miseries. And we don't share that. And consequently, as I say, we have a limited role to play. Essentially, we're a sort of a portable data bank with comments. Now, one of the interesting things about this experience, in contrast, and it's interesting to compare to the experience here in the United States, is that the topic for this panel would never occur to them. How effective are bills of rights? And there's a certain irony about the whole thing. I mean, so much rhetoric about the Bill of Rights. I guess so much blood has been shed for some of the rights, and yet we still ask questions like that. And partly because there are free societies without bills of rights, the United Kingdom, Israel, and there are other societies which, as Ted indicated, Iraq, Soviet Union, and elsewhere, which have wonderful sounding bills of rights, but very, very different kinds of societies. In fact, I think it's fair to say that in this country, except perhaps for the property provisions, and that was really the 14th Amendment, but I'll run them all together, sort of, because in most places, equality, 14th Amendment kind of stuff is considered part of the Bill of Rights, and I think it probably should be in our country as well. For the first 140 years or so, there wasn't much of a Bill of Rights. As you may know, the first speech case was 1931, here against Minnesota. And the Bill of Rights, this short list of articles, which has gotten so much rhetorical attention, didn't amount to a hell of a lot in the life of the country, at least not overtly. And this reflected, and we're talking a lot about Madison, I think Madison was actually a good deal more ambivalent about the Bill of Rights than some of the conversations. His real hostility to the Bill of Rights, I think, at least according to the history I've read, not sure there are differences, was based on the fact that he saw the clamor for a Bill of Rights as a phony diversionary tactic, really an attempt to derail the whole Constitution, to delay things. As you may recall, Patrick Henry and some of the others actually called for another convention, which would put things off 2 or 3 years. And since Madison, the whole thing was such a dicey proposition, Virginia passed by 10 votes, I forgot what it was in Massachusetts, elsewhere, well, it wasn't a hell of a lot. It was a near thing in a lot of places. What he saw, and those of us involved in political matters tend to focus on the thing that bugs us. He saw it as essentially a diversionary tactic. And he also, having seen what he considered the impotence of the Bills of Rights, on the state level, because he was very troubled, as you know, about the state legislatures, which he felt were trampling the rights of many people, particularly the rights of property. And he wrote to Jefferson, what good do these things do? And in fact, even in Virginia, he says, where we have a Bill of Rights and where we include religious freedom, I don't know if we'll be able to stem the tide of religious establishmentarianism. So he said, I don't think they amount to much. However, he said they do have some virtues. And he said one of the virtues, of course, is that they can become part of the sentiments of the society. They can be seen as maximums, fundamental maxims of a free society. And he said that's a great virtue. He said they're weak, very weak, in a country where you have a power, where the legislature is supreme as opposed to the monarchy. In a monarchy, he said, I think they serve as a rallying point and may even serve as a way for what he called the stronger power, the popular will, to rise up against the monarchy. He said, but in a country in which the legislature is all powerful, he felt this was a great danger in the United States, it doesn't amount to much. As you know, Jefferson, and despite the reference in Federalist 84, there is Federalist 78, Jefferson and Hamilton responded to this in a way, Jefferson directly, by saying, what will be involved here, which you will omit, is the courts. These will become part of the law for the courts to enforce for an independent judiciary. And that, I think, contrary to the thrust of the comments of my friend Baker, that I think is one of the great contributions of the United States Constitution and the United States to the world. And although we still fuss about it here, despite 200 years or despite some 50 years since 60 years since 1930, when the Bill of Rights began to be enforced, I think, more meaningfully, in Europe, there is no question. The new countries all recognize the need for an independent judiciary to enforce the Bill of Rights. In the Czechoslovak Constitution, they just adopted a Charter of Fundamental Freedoms. Havel said he wanted that to be the first order of business. He wanted it to be November 17th, the anniversary of the start of the Velvet Revolution, but he said it in September, and that was just ludicrous. But the fact that it was ludicrous became, I think, of some significance, which I'll touch on in a minute. He then said he hoped it would be December 10th, Human Rights Day. As it happened, it was adopted second. The first was a division of power between the central government and the two republics, and it was adopted January 9th. And it was in two parts. First, the enacting constitutional amendment, and then the charter itself. The enacting constitutional amendment, section 1 says, Section 1, paragraph 1 says, constitutional acts, other laws, and other legal regulations, their interpretation and application, must be in accord with the Charter of Fundamental Rights and Freedoms, which is this. So it establishes the supremacy, I don't know how this is going to work, about the relation between one constitutional act and another, what makes one superior to another, but that's the way they wrote it. Secondly, the fundamental rights and freedoms listed in the Charter of Fundamental Rights and Freedoms are protected by the Constitutional Court. And the Constitutional Court provision was passed last Thursday, after a lot of worry and wrangling, arising primarily out of the conflict between the Czechs and Slovaks, which incidentally, as a side issue, dominates Czech politics. So that they recognized it, and I think almost every other country recognizes it. And I think the fact that they don't have, the fact that you need a court, an independent judiciary, has all kinds of other implications. Because an independent judiciary, by definition, if it does its job, is going to be unpopular. You don't need an independent judiciary to adopt the popular things. And to do the unpopular things, you need a court that's a strong court, confident of itself. You know, the United States Constitution is, after all, built, regardless of whether we'll disagree more to how much more or less, better or worse, very much on the strong judiciary. But we've had 200 years, and John Marshall to begin it, who started the process of a strong judiciary. In Czechoslovakia, for example, they have a compromised judiciary. God knows, I think 100 or 150 have resigned, and another 100 have been fired. It was a communist regime. They had what's called telephone justice. In any case, the KGB or the prosecutor called the judge on the phone and said, this is the way this is what the sentence will be. Those of us who, and I have represented people in communist situations, know that it's a political thing. The whole thing is, you know, in advance. For a long time in the Soviet Union, Jews who wanted to emigrate, who they decided to frame in one way or another, got 3 years. If they were allegedly found with hashish, as somebody I was involved with, in his bag, a cellist who had never smoked marijuana or anything like that in his life, it turns out he was charged with having exactly the right amount. A little more would be more than 3 years, a little less than 3 years. Exactly the right amount. So you have a serious problem. The problem of legitimacy, the one in the sense that still plagues us, is what's crucial here. And for that, you may need a much longer constitution than what we have. We have a habit of saying constitutions should be very short. Our constitution is not short. Our Bill of Rights consists of the Bill of Rights, the 13th, 14th, and 15th Amendment, a couple of others, and 200 volumes of the U.S. reports. You don't get much out of the language. You get it out of the reports. They don't have 200 years. They don't have our court. So they have to have a different kind of constitution. And perhaps a different kind of court. It affects the whole question of judicial selection, judicial tenure. Different countries are different. Poland somehow, I think because of the hatred of the Russians and hostility to the communists, retained an independent bar and retained an independent judiciary. Other countries have managed very quickly to get these courts. The German Constitutional Court, Mr. Weinbein can probably tell you more about that, but I've been told that, interestingly enough, most of their business today, and it's a very powerful court, is in the human rights area. Now, the effect of this is multiple. An English civil libertarian has commented that one of the problems with the English system is that they have neither judicial review nor a Bill of Rights. The result of it is that they don't have lawsuits, they don't have civil rights lawyers, they don't have any civil rights law, and it's not taught in the universities. So as a result, they have a very thin culture. In Israel, they have a court, and a pretty good one. Okay, I've run over my time. Let me just close with just a word or two about some of the things they've done. They've adopted economic and social rights. I disagree, Ted. I think that the reference to rest and leisure in the Soviet Constitution did mean something. It meant that all workers got free vacation. These rights can have an impact. The right to an education means a great deal in Czechoslovakia, where you weren't allowed to go to a university if you were on the outs with the Communist Party and your family was on the outs. Constitutions reflect a variety of things, and I think that I obviously have talked more than I should have, but I think that these constitutions have a lot more to justify them than us, than we coming out of our rather narrow and specialized experience often. Thank you.
Perhaps Judge Easterbrook can give us another perspective. Where do we start to create a government that protects freedom and civil liberties? Is it a Bill of Rights? If it's not a Bill of Rights, what is it?
I'm not sure I can answer that question. Lawyers seem always overemphasize the importance of rights and law in general. Maybe we're just doomed to have everybody think very highly of his or her own field. It's always seemed to me that the political and economic culture is much more important for our individual liberties than our things written down, parchment barriers. Liberalists wrote our Bill of Rights but thought it unimportant. Not wholly because the Constitution had created a structure of government that would hold down occasions for infringements of liberty, although Madison thought that was important. Risks would be reduced, although not eliminated. And certainly not because he feared that to list some things would imply hidden powers. The Ninth Amendment took care of that. He had instead something of the sentiment that Leonard Hand later expressed, and I'll paraphrase Hand's line, that a society where the spirit of liberty reigns, no court need say. A society so striven that that spirit is dead, no court can say. And where the courts displace the people and the legislature as the guardian of that spirit will in the end perish. Madison did not want to count on parchment barriers and hoped they would not become the important feature of our civic community. He expected very few violations at the national level anyway. Professor Schwartz said he was concerned about the states. And at least at the national level, he was not surprised. During his lifetime, the Supreme Court did not decide a single case under the Bill of Rights. History has really vindicated that view, not because liberty is unimportant, it's very important, but because the principal guarantees lie in our civic culture and not in legalisms. Now, one class of reasons for that conclusion is trite, I suppose. That is, that the court follows the election returns. There is enough plasticity in our Bill of Rights and enough forgetfulness about our history among those living that our own Bill of Rights has been remade in contemporary English several times. Well, maybe contemporary image is the wrong word for it. Sometimes it's remade in the contemporary political image. Sometimes it's remade in an image that has died but lives on in superannuated justices. And sometimes it is remade in the image of a Christmas future, that is, justices now living who think they understand what our image will be sometime in the future and attempt to remake the Constitution in that way. But we have had enough changes in it to doubt that it is the Bill of Rights that is being vindicated as opposed to some vision of civic culture that is being imputed to the Bill of Rights. One ought to consider our own track record. We got along without a Bill of Rights in this country into this century. We know, for example, that it wasn't applied to the states, with the exception of the Takings Clause, which got applied to the states in 1887. It was largely not applied to the states until the 1960s. As for the federal government, the 19th century passed with very few applications of the Bill of Rights to the federal government. The first was a fiasco. It was Dred Scott. You may recall the claim of Justice Tawney and Dred Scott that it would violate the due process clause of the Fifth Amendment to entertain the proposition that a black man might be free. Well, that was not an auspicious start, I'm afraid. We come to the period of incorporation in the 1960s. It seems to be forgotten, but it ought to be remembered that what was being incorporated were provisions that were in almost all of the state constitutions at the time, and which most of the states were doing voluntarily under their own constitutions before the Supreme Court applied the federal constitution to them. It's very difficult to track down important changes in the American culture and rights that can be attributed solely to things that have been incorporated. Now, there are, of course, some spectacular examples that are usually given as counterexamples to such claims. Now, I had in mind, of course, Brown against the Board of Education. Brown was, of course, terribly important to national consciousness. But if you look at what Brown did as a legal decision, it's very limited. The amount of desegregation in schools in the wake of Brown was quite small. It took a series of federal laws, statutes passed by Congress, to fulfill the promise of Brown. Those statutes were passed largely in the 1960s, and what we now think of as the civil rights were achieved largely by statute, the most important being the Civil Rights Act of 1964, applying civil rights principles to private institutions. And the Voting Rights Act of 1965 carried out at long last the promise of the 15th Amendment, which had never been fulfilled just because it was in our constitutional list. It needed a statute, it needed a political debate, it needed a change in our civic culture. How about the religion clauses? Religion was something that was debated at the beginning of the Republic. But it's important to remember that the First Amendment religion clauses were not applied to the states until 1952, by which time they had all given up their established churches, those that had established churches, voluntarily, without the need for constitutional rules. They had made their own changes and accommodations. And if you look around in other places in the world, you should notice that even those nations that have officially established churches now have the kind of mild establishment that is establishment in name only. There was a time when the establishment of churches in the United Kingdom was a source of great bloodshed. They still have an established church. In fact, they've got two, the Church of England and the Church of Scotland. But it is no longer a source of either bloodshed or oppression. That was not as a result of changes in the Constitution, but of changes in civic and political culture. Let me give you one more example from our culture, and that is abortion. Roe against Wade is sometimes given as an example of a terribly important application of constitutional rights and the Bill of Rights. But if you look at the number of legal abortions performed in the United States, a figure that you can go look up if you wish, you'll find that the number started a dramatic upswing in the late 1960s, continued an upswing through the 1970s. And if you look in 1973, the year of Roe, you do not find a blip. That is, there's no change in the rate at which the number of legal abortions is increasing. Before Roe, there were dramatic changes in state laws, at least in the laws in some states, and they were underway in other states, that contributed to a rise in the number of legal abortions. Perhaps I'm going out on a limb, since it can't be falsified, it's an easy limb. I don't think Roe made very much difference in the number of legal abortions in the United States. Had there been no Roe against Wade, the trend in changes of state laws would have continued. And if you look at the chart that was available on number of legal abortions after Roe, that chart would not have been much different. It would have been any different had that case never been decided. It was a nice focus for debate. It's still an important focus for debate. Such questions are terribly important at the level of theory. Whether they are important at the level of practice would depend on knowing exactly what would have happened to the state laws that were in the process of change at the time Roe was handed down. Now, there are some ways to check propositions of the sort that I am making. One is to look at state constitutions. The language of state constitutions differs. One can ask to what extent there are important differences in the rights of the people, tracking those differences in state constitutions. It's very hard to observe those things. One can ask to what extent there is sound evidence that the language in our own Constitution has made large differences. Cases like Roe against Wade are from outside its language. And of course, the express language is ignored as often as not. The takings clause, you will all recall, applies to the federal government and not to the states, but it's been applied to both. The contracts and equal protection clauses apply exclusively to the states, but they are in practice applied to the federal government as well. A right to travel has been embedded, and some rights have been disfavored and shriveled when they fell out of favor with modern political culture. And the whole enterprise has become dominated by balancing tests, which aren't really tests at all, but they are lists of factors which enable the justices to make the content much more plastic, much more responsive to contemporary views about what is wise and good. Now, perhaps to examine this argument more fully, one has to look outside the borders of the United States. I won't look at Eastern Europe. But I will ask you to consider the differences in the constitutional structure of the nations of the West, because they have very different constitutions and very different judiciaries, but quite similar liberties in practice. The United Kingdom is, of course, familiar to you. It has no constitution, it has no judicial review, but it does have a tradition of the rule of law situation similar to the United Kingdom until the 1980s, when it adopted a Bill of Rights with judicial review, but put in a notwithstanding clause. That is, if something is deemed unconstitutional by the Supreme Court of Canada, a province can reenact the law notwithstanding the Bill of Rights. All it has to do is claim specifically that it is enacting this notwithstanding the Bill of Rights. And of course, the United States has its own notwithstanding clause. It is sometimes forgotten that there's a provision in Article 3 allowing Congress to curtail the jurisdiction of the courts. Congress can, of course, abolish people like me tomorrow. It can abolish all the work of the courts and can make exceptions to the jurisdiction of the Supreme Court. That power has not been used extensively, it's been used only rarely. That power has not been used extensively to pull the constitutional teeth from the Bill of Rights is a tribute to our political culture and not the formal written legal document. How about Germany? Germany does have a constitutional court, and it does have judicial review. It's a judicial review that, by the way, has become localized in recent years. An increasing series of cases coming down to protect property and business interests, and to review the wisdom of legislation, that is, to demand that legislation actually be justified by good ends in a way that hasn't happened in the United States since the Obamacare. Then there's France. Now, France has a constitution without any significant list of rights to it, and it has no judicial review as we know. There are two main separate court systems, the Conseil d'État for review of governmental action, the Cour de Cassation for private suits, and neither of them believes it has the right to engage in constitutional review of legislation. The Conseil Constitutionnel is their constitutional court, but it is limited to advisory opinions. That is, it can issue opinions only at the request of political figures, and only before an act becomes law. Once the act becomes law, it is locked in place. And the Conseil Constitutionnel, by the way, has concluded that in addition to the rights listed in the Constitution, the constitutional rights of France include the Declaration of the Rights of Man from the French Revolution. Again, the idea that what is written down is important, is controlling, is I think very hard to maintain when you see these very different systems producing similar liberties in practice. And we're seeing similar developments, by the way, in the European community. Their principal court, Luxembourg, has on its own initiative adopted a list of rights culled from national constitutions and European conventions of rights. Paradoxically, it did that to expand the power of the EC, because it was afraid that some of the member states with their own constitutions, Germany being a good example, might refuse to go along with EC directives if the EC did not have its own list of rights. And since there really wasn't any in the Treaty of Rome, the court did it. So my advice to you is to take with skepticism claims that bills of rights are important in themselves. And it is a political and economic culture that nurtures claims to individual liberties, that supports it, and that alternative institutions are found in other nations and at other times to protect liberties when formal bills of rights are absent. In our own current legal culture, it is very important. But in its absence, things would grow and change, the culture would adapt, and I expect we would be living in very much the same country. It's always worth doubting, at least, the omnipotence of the Constitution, even though it happens to be our civic religion.
Judge of the United States Court of Appeals saying that the Bill of Rights is totally irrelevant and has no impact on, I presume, the decisions that he makes with respect to the rights of citizens and engagements that come before him. Do you agree that this country would be exactly the same without the Bill of Rights?
Well, first of all, Ted, I'm sure that it is true that the Bill of Rights has no impact on the way in which France is. I do not agree with the proposition of Bill of Rights. In our country, has been consequential begin, before getting into that, to say that the central message that I come away with, having listened to Ted's opening remarks and the other panelists, is that a question like the efficacy of the Bill of Rights really cries out for serious comparative legal scholarship. Perhaps on the nature that Bob Ellison was talking about last night, looking at different state constitutions, and I think Frank also alluded to this. We're looking more seriously at the different constitutional regimes around the world and trying to draw some judgments about what the impact they have. Of course, there were various expressions of skepticism about this morning, but there really is very little, I think, serious scholarship by constitutional law people in this country on this point. I think the scholarly tradition in America has been extremely myopic with excessive concern with Supreme Court cases and to some extent the history of our own constitutional development, paying very little attention to constitutional developments elsewhere and whether or not these things make any difference or an impact. I would readily acknowledge the difficulty of doing comparative work here. We have very serious definitional problems trying to decide what the list of liberties or rights would be that we would use as a benchmark, trying to decide whether the scope of rights is more important than the security with which rights are obtained, trying to decide what's important, how rights are protected. Do we automatically think of rights in terms of litigation and judicial protection? Do we have some different approaches to rights? But I really do believe that that if we make too much headway in answering questions like the one before the panel, more serious work needs to be done. I fully include myself in this indictment. I have no pretense of being a comparative law scholar. So the thoughts that I'll offer to you should be taken with a very deep discount. My own sense of things is that in the final analysis, as Frank has suggested, it's the culture, the legal culture perhaps, that really makes a difference. And so, as Professor Schwartz has indicated, every culture is unique. So to that extent, I think perhaps we can never come to a complete final assessment of this thing. But I think what would be useful would be to try to identify institutional factors that vary across cultures to see what extent they do make a difference. And it seems to me at least three would be likely candidates to make a difference in terms of the robustness of individual liberties. The first would be the extent and health of the system of private property. Professor Epstein last night, I think, spoke convincingly about the importance of decentralization, a decentralized system of economic rights as being an important basis for the protection of other civil liberties, including First Amendment rights, Fourth Amendment rights, and so forth. And I think there's really a truth to that. I think if we did undertake this hypothetical comparative study, we would find a strong positive correlation between capitalist regimes and regimes that have a rigorous private property system and those that protect civil liberties that we tend to think of in this country. The second institutional factor that I would predict to be of some importance would be divided government. The logic here would be at the federalism level, if you have a government which is divided vertically and some decision making is relegated to the local governmental entities, the people can vote with their feet if they don't like the repressive measures adopted in one jurisdiction and transferred to another. And at the federal level, at the national level, I think divided government is important because it basically means that you have to achieve a consensus among three branches of government before you can undertake to repress the liberties of the citizen. So in effect, the divided government acts as a kind of supermajority rule, or perhaps, or if not a supermajority rule, at least a cooling off rule that allows second thoughts to be had about those particular repressive measures before they're implemented. England, for example, when the Gulf War broke out, very quickly instituted a system detainment of Iraqi nationals and other people with suspected of terrorism in this country, where we would have had to have enacting legislation, regulations adopted, and pre-enforcement judicial review before we could have gotten such a thing up and running by the time all that was completed, the war, of course, was over. The system of divided government, I think, can add this measure as a further protection of liberty. And I would disagree with Frank. I think that, let me put it this way, I think bills of rights by themselves are probably not terribly significant text and anecdotal discussion of bills of rights are not really suggest. But I think judicial enforcement, enforcement of bill of rights by the judiciary does make a difference, and you can think of this as another variety of the supermajority type of protection that, in the long run, of course, the legal, the culture and social norms will win out. 90% of Americans come to believe that suspected drug dealers should be lynched on the spot. Eventually, we'll have a constitution that says that drug dealers, suspected drug dealers, should be lynched on the spot because the Constitution is broad and plastic and subject to various interpretations, and if the judiciary doesn't respond to the popular will, eventually they can be replaced, or their jurisdiction can be taken away, or the executive can refuse to follow their judgments or whatever. But before we reach that kind of limit, I think that the independent judiciary enforcement bill of rights does act as a break or a further impediment to majoritarian impulses toward repression. And in that sense, provides a further measure of protection beyond what you get from divided government, or what you get from the kind of cultural norm of the mutual toleration and respect of taking law. What I'd like to sort of focus on including would be the thought that these various institutional factors that work to protect rights not only exist in some kind of sequential or hierarchical relationship, but they have important interactive relationships as well, and a complete understanding of how our constitutional system protects rights requires some appreciation of that. One point could be summed up in the word redundancy. It's useful to have both a system of divided government and a bill of rights enforced by the judiciary, because sometimes one or the other of these mechanisms will default and need the other one to provide protection in lieu of it. For example, one of the rights mentioned in the Bill of Rights is the right stated in the Second Amendment to bear arms. The Second Amendment states that the reason why we have this right, but it doesn't suggest that the right is in any sense limited to the implementation of that reason alone. The judiciary in this country, to say the least, has done very little to enforce the Second Amendment right to bear arms. Perhaps because intellectual elites like the ACLU, as we heard last night, don't really think it's a right. Perhaps because the judiciary, which lives by the pen, is not terribly enthusiastic by those who live by the sword. But nevertheless, notwithstanding the complete judicial default in enforcing the Second Amendment, we have a rather robust ownership of firearms and other weapons in this country. I think largely because of the federal structure that we have. People in Wyoming that have different views about this than people in New York City or Chicago. And to the extent that policymaking has evolved at a local level, we have different regimes here. And our divided government at the national level has allowed people with strong views on this point to bring to bear disproportionate influence relative to what you might have in a single parliamentary regime. On the other side of the coin, I think the Bill of Rights enforced by the judiciary frequently steps into the breach where divided government fails. The flag burning legislation is a classic example. A huge wave of public sentiment in favor of repressing flag burnings crashed easily over bicameralism and presentment laws, but ended up being stopped by a 5-4 vote in the Supreme Court. And by the time the court had twice declared that flag burning was protected by the First Amendment, public passions either cooled or had diverted to other questions. And it seems to me that we're relatively secure in our right to burn and celebrate the American flag for the foreseeable future. Another point would be complementarity. I think it's a mistake to think of the Bill of Rights as encompassing everything that counts, all rights that might conceivably be important. And to the extent that the Bill of Rights is incomplete, then our structural protections may offer stopgap measures of support. For example, people that think that, as we discussed last night, that homosexuals ought to have the right to be free from official acts of disfavor or discrimination, are probably not going to get much solace from the Bill of Rights in the foreseeable future. The Supreme Court has decided that sexual preferences are not fundamental rights protected by the Constitution. But again, if you look around the country, you see many local communities that have ordinances establishing human rights protections that include sexual preference. And so our federal system of government has provided a measure of protection under the Bill of Rights regime that protects rights. So on the other side of the coin, aliens are an example, I think, of a group. And this, I think, is a concrete example where the Bill of Rights has made a difference, contrary to what Frank suggests. Where because of their lack of enfranchisement, probably did not expect much protection from state and local governments, but the Supreme Court has intervened in the equal protection clause and provides equal protection for them. Finally, I will mention certain, if you want a better word, I hate this word, synergistic effects that exist between structural provisions and the Bill of Rights. One, I think, is that a system of divided government is more likely to have a confident judiciary than is a unitary or parliamentary regime. If the judiciary, basically because the judiciary can play a game of divide and conquer, if the judiciary faces a single unified political apparatus, it's likely to be much more timid, I think, in confronting that apparatus. But if the means of control of the judiciary are divided between the executive branch that appoints judges and has a lot to say about control of the caseload of the judiciary, and the legislative branch, which appropriates funds to the judiciary and jurisdiction, then I think the judiciary will be more confident about asserting itself and would be especially more means of control of the single hand. I think also that the Bill of Rights, on the other hand, can have important effects in protecting structural freedoms or other institutional freedoms. The takings clause, for example, which protects property against confiscation, helps foster a vigorous regime of private property, which I would argue is helpful in underscoring the system of liberties. The Fourth Amendment protects those who like to bear arms, even if the Second Amendment is not enforced by the judiciary, and so forth. And finally, and I think this point's already been touched on, but it bears emphasis, there's a feedback loop effect, if you will, between a judicially enforced Bill of Rights and a general cultural attitude of appreciation for liberty. Of course, if the judiciary does a poor job, you can have a bad negative feedback loop, I suppose. But I think by and large, the Supreme Court has done a good job of protecting the liberties in this country and has lent the great prestige of the law to the cause of freedom. And as a consequence, we have a much greater tradition of toleration and mutual respect in the country than we would have otherwise.
I think we will follow the same format as we did last night. In my experience with Federalist Society gathering institution, there's no lack of interest or capacity of members of the audience to participate and contribute greatly to the dialogue. But before we do that, I'd like to give each of our panelists 2 or 3 minutes to respond, 2 or 3 or 4 minutes to respond, hopefully not too much more than that, to respond to what they've heard. We've got a full range of ideas with respect. I haven't heard one mention of the word Magna Carta or the Bill of Rights of 1688, but maybe that will come up. Perhaps we'll start with Professor Baker.
I'd like to pick up and take issue with Professor Merrill on his approach to things. He talks about divided government on the one hand and then something separate, court enforcement of the Bill of Rights. Well, first of all, in separation of powers, the court's role is part of the divided government. It's not something in addition. Moreover, in the example he gives on the flag burning, and which I would expand to prayer, busing, and abortion, I think he ignores the dynamics. That is, why do we get a stampede mentality in Congress on the flag issue or other emotional issues? It's because the court created the problem in the first place. Prayer, abortion, busing, the flag, all were instances in which the court had interfered with an issue from the states that created a very emotional backlash and not able to get any response, obviously, at the state legislative level, having been cut out by the court from doing anything. The people's immediate response is to go to Congress. This raises to the national level issues that were never intended to be at the national level. One of the reasons for federalism is to protect the federal government, not just to protect the states, by leaving at the state level emotional issues so that the federal government doesn't get tied up in knots over these issues. And so the court is the one that creates the situation in which we get a herd or stampede mentality through the Congress, and then the court comes to save the day of the mess that it's created in the first place. So I don't see that as necessarily helping things. I see it as part of the increasing statism. And it's interesting from a comparative point of view, because when I talk to law professors from other countries who, if they lived in this country, would be members of the Federalist Society, I'm astonished, or was initially, to find out that what they want is more judicial activism. And the reason they want more judicial activism is because they come from statist regimes and they see no other check on the power of government, and they look to the idea of an independent judiciary to check that government. Now, if you look at our own country, all have agreed here that the Bill of Rights didn't mean much in practice until about 50 or 60 years ago. That is because in the middle 30s, the court changed its attention from checking Congress to checking the states. They wanted to pick on somebody they could handle. And in doing so, it is at a time when we consolidated power in the administrative state, when even so-called conservatives like Cardozo thought that separation of powers was an antiquated doctrine that was not important. So by ignoring separation of powers and crushing federalism, two of your basic protections for liberty, yes, then of course the Bill of Rights takes on increased importance, because in a statist society, you need a certain breathing space when you're confronted with a consolidated government. But if we didn't have consolidated government, then we wouldn't be placed with reliance only on or emphasizing that one aspect. So other countries, whether in Western Europe, especially in France, or whether in Eastern Europe with their terrible experience over the last 40 years with a very statist government, they are concerned to check it. But both those who would be Federalists over there and Federalists over here are concerned with statism, and they're concerned with checking the power, and they're concerned with balance and limited government. But what it goes to show is that what it takes to get a balanced government or a limited government will depend on different factors in different countries. And it is dangerous, I think, sometimes to live out, as our State Department and other people do, lived out a particular institution out of our own system and transplant it into another culture and governmental situation, because the impact and results will be different from what they are in this country. And we know what happened when those who observed our revolution went back to France, and they thought they were merely following our example.
I'll leave Mr. Merrill to respond to Mr. Baker's remarks. So I will say the thought that the founding fathers, we just lived through a revolution and all kinds of bitter problems in the 1780s, were looking for a quiet life by creating a national government is a little bit startling. You said the emotional issues were to be at the state level. There are lots of emotional issues which they anticipated: press freedom, slavery, all kinds of, and party politics that they expected would be fought out at the national level. You don't distinguish between national and state on the basis of what's emotional.
Well, they did enumerate powers. They didn't put police powers.
Well, we can discuss that some other time, but I really wanted to respond to a lot of the points in Mr. Easterbrook, Judge Easterbrook's comments. Let me say I want to associate myself totally with Mr. Merrill's remarks about the Bill of Rights being a brick. That's really what its functions. Learned Hand's views are brilliantly put in this typical lapidary style, but are, as are Judge Easterbrook's, extreme. Nobody expects a Supreme Court or any judicial system to save a society that's going to hell. And many of us are very, very worried about the rise of fascism. There's an interesting book by Ralph Darndorf on Eastern Europe, regardless of all these bills of rights and even judicial review, because the economic and social fabric is so fragile and so no with it. So, but in a society that's made it to some extent, it helps and can do a lot. And I think the flag burning example is a perfect example. We got along without the Bill of Rights for a century, yeah, and we had extreme repression in the South in the antebellum period of press freedom and letters and all kinds of speech. Would incorporation earlier have made a difference? I don't know. This wasn't paradigm. Hard to find important changes that can be attributed solely to the Supreme Court. Well, apparently Mr. Baker disagrees. And if you talk to police in a lot of places, they will tell you that Mapp and Miranda, not I think Miranda less, but Mapp has transformed police work, and many of them will tell you for the better. Brown, as a legal decision, didn't have any impact. Well, we wouldn't have had the legislation but for Brown in the first place. And on schools, we have precious little legislation. Title IV of the Civil Rights Act of 1964 was very helpful, but without Green against New Kent County in 1968, I don't know if we would have had even the amount of desegregation that we do. And in addition to which, some of you may recall that the Supreme Court came under tremendous fire for a series of per curiam decisions right after Brown, in which they abolished segregation in parks, swimming pools, and a whole variety of areas, with one line per curiam saying the decision below, state court decisions, are reverse Brown against the Board of Education. I remember my constitutional law teacher, Ernest Brown, criticizing this severely. With respect to abortion, well, I don't know about the statistics about 73, but prior to 73, there were 13 district court and federal court decisions on abortion, 9 of which struck down their state abortion statutes. You had the Bellows case in California, which was of enormous significance. You also had legislation in New York, terribly important legislation in 67 or something like that. How to put all this together, I don't know, but it strikes me that it's very unlikely that poor women in Missouri or Arkansas today, or Pennsylvania, would do very well in getting an abortion, regardless of whether the total numbers. The United Kingdom, without a constitution, well, English lawyers have written and said that among one of their major problems is that they don't have sufficient protection for minorities. They have an Official Secrets Act, and of course, Mr. Merrill referred to the problem of Iraqi detention. The weakness of the French court, well, they said there's a right to abortion, drawn out of the rights of man. And finally, the European Convention. The European Convention has finally done something that I don't know how many years of English history it's not been able to. It's introduced judicial review into the United Kingdom, because there have been a whole series of decisions by the European Convention on prison conditions and other matters which have been adopted and enforced by the British government, following that. So that you talk to Israeli lawyers, they will tell you that although they think their court's pretty good, there is a crying need to have a Bill of Rights to override their very strong parliamentary systems.
Russell will defend the view that he doesn't need a Bill of Rights to decide cases.
Let me say that I really don't disagree with anything Professor Schwartz has said. What we have are really differences in emphasis rather than differences in understanding the importance of Bills of Rights. In our particular political and legal culture, the Bill of Rights has proved to be, and the institution of judicial review has proved to be important. The point I was making is that there are substitutes that others from a similar general view of appropriate cultures produce. We produce an emphasis using the Bill of Rights. I don't want to deny the importance of that in the United States, given the way in which we've chosen to achieve individual liberties. Although one has to approach all of these questions with a suitable degree of skepticism, willingness to look at the divergences through our own history, willingness to look at the institutions used in other nations that have achieved roughly, although obviously not identically, similar results. I do want to say a couple of things about Professor Merrill's examples, though. I think they show something not in opposition to the point I was making, but really consistent with it. One example, which is striking when you first think about it, is the difference between the British reaction to Iranian nationals and ours. And as Tom Merrill says, the British picked off many of the Iranian nationals, and we didn't. He attributes that to our Constitution, but I don't think that's a correct attribution. You may remember what happened during World War II. Without the need for legislation of any kind, United States citizens of Japanese ancestry were picked up and imprisoned on the West Coast. And the Supreme Court of the United States held that that is consistent with the Constitution. There was no statute. There was no debate in Congress. It was done on a general say-so. Now, many people think Korematsu is a disgraceful decision, and I'm among them. But if one asks what the status of rights were in the United States so far as the Constitution is concerned, would the Iranian nationals have been picked up without clearance from the Constitution? The answer is yes. Now, we didn't pick them up, and I think that says some very good things about our political culture and the degree of tolerance in the United States. But given Korematsu, it's not possible to attribute the Constitution in the United States. Aliens are actually a very good case for thinking about what the Constitution has done and what it has not done. The Supreme Court has said in a number of cases that aliens have no substantive rights against the national government. They may have some against the state government, but not against the national government. But Congress has created for aliens a very large panoply of statutory rights, none of which can be traced to the Constitution, but many of which are very important and well worth enforcing. Abortion gives another sort of example. The thing about what has happened after Webster, which implied that states might have greater control over abortion than had been the case in the preceding 15 years. What has ensued in many states is a responsible political debate, an ethical debate, of the sort that was missing beforehand. I'll just give one example. It's my home state of Illinois. There was a cycle for about 15 years in Illinois. Every 2 years, the state legislature would enact some draconian anti-abortion statute, knowing that it would, of course, be held unconstitutional by the Seventh Circuit. Well, the state would enact it, and it was, of course, held unconstitutional by the Seventh Circuit. And then after that was struck down, they would start up again. The next legislature would enact another. We went through this cycle. Webster comes down, and it suddenly becomes clear to the Illinois legislature that their statutes might be upheld. The very first thing they did was settle a pending case on terms favorable to the women seeking abortions. And then in the next cycle of the legislature after that, no legislation was pursued. In other states, there have been responsible debates. But it was clear that irresponsible legislation was being passed in the belief that the federal courts would allow these people to have whatever, to say whatever things they wanted to their constituents and not be responsible. We would take care of it. The increase in civic responsibility caused by Webster is, I think, one of the virtues of such a decision.
Professor Merrill?
A number of points. First, with respect to whether an independent judiciary is part of the government or something else, I don't think that too much turns on that. I think it's sort of a definitional issue. Clearly, an independent judiciary is part of separation of powers classically understood. I think, though, you can analytically distinguish from the existence of an independent judiciary the question of whether or not there will be a judicially enforced Bill of Rights. There are countries like France, for example, as we mentioned, that have a traditional separation of powers and a system that is somewhat separated, but nevertheless do not have a strong tradition of judicially enforced bills of rights. Although they do have a Bill of Rights, frankly, the original Declaration of Rights of Man in 1789 is incorporated by reference to the Constitution of the Republic.
Only according to the Olson Constitution.
I'll keep those 2 points distinct for discussion. I think it's going to help to do that. Secondly, a couple of speakers, both Professor Baker and Judge Easterbrook, have suggested that there was a radical shift in this country in the direction of judicial activism, specifically with regard to state activity that took place in the 1960s or thereabouts. And I think this is a little bit misleading historically. Now, it's true that the Bill of Rights, in the sense of the first 8 amendments to the Constitution, were not robustly enforced against the states until this century. But if you go back to the 19th century, we'll find legions of cases, mostly decided in the contracts clause, in which the Supreme Court of the United States invalidates various kinds of state legislation. I think the numbers are well in the range of 200 in the 19th century alone. And so I don't think judicial activism in the sense of the Supreme Court and federal courts validating state laws in order to protect judicial activity from state majorities is in some sense a radical new development in our political culture. Also, with respect to the point that the Federal Bill of Rights or federal enforcement simply tracking what state courts were doing, that does have federalism significance, but it doesn't change the point that there was something called judicially enforced bills of rights as part of the legal tradition of this country. It simply had the form shifted from the state courts to the federal courts in part, although the state courts are still very active. Finally, with respect to the point about courtmartial and detention, I think if I were appointed legal advisor to General Colin Powell, and he came to me the last few months and said, tell me, I would like to start a series of detention camps in this country for Iraqi nationals in order to forestall any possible terrorism. Is it all right if I do that legally? I would not have brandished the court-martial decision and said, yes, General, go right ahead, there's no problem. I think I would have said, when it was a predicted matter, that he would be in deep trouble if he tried to do this, because I wouldn't be able to predict exactly where it would come from or how it would manifest itself, but our legal system would not tolerate it. So I think really the point, I think I agree with Frank that there's some shading and degree between, let's say, our system and the British system in terms of how protected we are of liberty, but I think the point may simply be that England is about 50 years behind the United States in terms of the degree of protection of the rights, at least with respect to this particular issue. So I still take issue with the point. Finally, this whole theme about emotional decisions and whether they should be located in federal courts, the state legislature, and so forth. It's very interesting, and I don't have an answer to that. I think that if you look at the abortion issue, I agree completely with what Frank says. I think that there's little prospect that the resolution of that issue by the United States Supreme Court is going to result in an emerging national consensus, a lowering of voices, general agreement on the path that the country should follow. I think that regime established by Roe was attributed to acrimony rather than alleviating acrimony. So to that extent, I think Webster is probably a healthy step in the right direction. On the other hand, you look at something like the flag burning episode, where again you have this tremendously emotional issue, which gets taken to the Supreme Court. The Supreme Court decides it, and then it all goes away. So I don't really have a theory as to how you distinguish between these phenomena. I suppose somebody who believes in the Constitution could say that the First Amendment's in the Constitution, right? Abortion is not. I don't think you can make any broad generalizations about this. Perhaps Professor Bates is suggesting that all emotionally divisive issues should be resolved in state level rather than federal level. Nor on the other hand, I think you could say, as a member of the civil libertarians market, that the very evidence of emotion and hostility suggests that we have important minority rights here that need to be protected by the federal courts. You can't possibly leave it to legislative determination because it's emotional. They can't be trusted to decide it right.
Do we have any comments or questions from the audience back here?
I'd like to make a broad generalization.
Speak as loudly as possible because we start.
Broad generalization is important to emphasize what we consider them to handle discussion, especially because they are at least. Broad generalization is that bill of rights are effective against the states and not the national government. Some statistics. These statistics have been important. There are only 9 cases in the entire 19th century that were important enforced in one of the bill of rights. 15 prior to 1925, and the Gibson case when the incorporation business began. What happens when the Supreme Court declares unconstitutional on bill of rights grounds? Judge Easterbrook mentioned the first time, Dred Scott, reversed by civil war in the first couple of sentences of the 14th Amendment. The second time, the Greenback case, directly after the Civil War, Congress authorizes the president to appoint 2 additional judges. They get appointed. The case comes up again next term, reversed. The third major time, Pollock against Farmers Holding Trust Company in 1895. The court declares income tax unconstitutional, constitutional amendment, so forth and so on. My conclusion is that the court cannot enforce the provision of the Bill of Rights against a determined national majority. It can enforce the Bill of Rights provision against the state majority in its ground focus, even a determined regional majority. So that the protection of these things really consists in, well, to sum it up, Congress does not pass enact laws respecting an establishment of religion. It simply doesn't do it. Something about the structure of the Constitution prevents that kind of law from being adopted. Not on a local level, etc. Okay?
Any response? Do we have any other questions or comments? Yes. Could you stand so we can all?
I was in Holland, Switzerland, very recently, and the jurist there said, we're talking about independent judiciary. He said, how could you people, first, he pointed out that the Hancocks are very jealous, that's the Federalist Society. And he said, how could you have a judiciary that's paid and is member of the beltway of the United States government, deciding a case where the states or an individual is on the other side. Now, what I told him, you got to know, this was raised in the Constitutional Convention, and you know it was decided first. I mean, Liberties, I think, said we will have a court composed of the president, the Congress, and its representatives, the states, and the court. Now that was voted down. I told this to him, that was voted down. And then he said, well then why did you have the justice, the judge, from only one branch, the federal branch? in a case, you get the point, don't you? So then I said, I think the reason is because they ended up saying all legislative power is in the Congress. Now, I want your gentleman's answer to this because I've got to answer this man back there. Why is it? I say the build-up in down here in Washington, build-up of power there is because the judges are members only of that. You get the point?
I think so.
In other words, the court is not composed of representatives of the state. It's composed of only one group. They are agents of the federal government. They're paid by the federal government. And you can't tell me that that is an impartial tribunal.
Professor Baker.
Well, what you have reference to is the voting down of the council provision in the convention.
That's right.
But contrary to some of the impressions that people seem to have thought of what I was saying, I am for a very strong federal judiciary. And I'm not dividing it between emotional and unemotional issues. I'm looking at the text of the Constitution to look at how they divide it into something called enumerated powers. But the issue that you are talking about goes to the role of the court itself. And the role in the convention was that the court was going to be a very strong weapon against the states. Now, I've talked
And the
about
federal court.
now, wait,
Yeah.
just a minute. They looked at the problem and they said, what's going to happen when we pass a law and the states refuse to follow it, as was the case of Commerce Clause and other things. So we've got basically two choices, force or something else. And instead of force, we substitute the Supremacy Clause, the rule of law, and judicial review. So the court is there to enforce the will of Congress, assuming that what Congress has done is within the parameters of the Constitution. And as pointed out by Professor Burns, the court seems to, in most cases, find that it is there. So it is a one-sided thing, and that's why Brutus, for the Anti-Federalists, realized that instead of being a buffer for individual rights, that the court would be very strongly working against the states in a certain sense. And this point was made by Professor Schwartz. Yes, the court has constantly been focused on the states and for reasons that the Federalists understood. But there was a division in the areas in which they were to focus and force the national will on the states. Primarily commerce. We haven't had to worry about defense too much. They haven't wanted to create a bomb or an army or anything like that. But in areas of commerce and other things where the powers were clearly given to the federal government, then the court was intended to have a very strong, forceful role, and judicial review was necessary to make it appear to be balanced, so that the states can raise the argument that, at least in theory, the possibility that the federal statute might be declared unconstitutional. And the only reason people keep coming back to litigate that issue instead of fighting over it is always the possibility that a federal statute might be declared unconstitutional, and every now and then we do it.
Well, as I hear you, the Federalist Society can't win.
It depends on what view of federalism you're talking about.
In the middle.
I'd like to make an observation and get the panelists' reaction. We talked about the legislation and the courts, and I want to suggest that the executive branch can be important to the protection of liberties. I'll make the observation, the reaction of two different presidents. One, Andrew Jackson, in regard to Native Americans in Georgia. The other, Dwight Eisenhower, with regard to the schools in Little Rock. It seems to me that the executive branch has a very important role to play in enforcing the will of either the legislature or the executive. And yet, that role is often ignored when we talk about protection of liberties. And I'm wondering what the panelist's reaction to that kind of idea is, that depending on whether you have Andrew Jackson or Dwight Eisenhower in the White House or similarities thereof, it doesn't matter who's on the court or who is in the legislature, the liberties that individuals or groups enjoy can be different.
We'll have a brief response from the whoever is prepared to respond to that, and then we're running very short of time, so we'll stop.
I think we all agree that all branches of government have a role to play. The executive issues executive orders. There's a big fight about an executive order on housing under 10 years' time. The federal contract power, but also the federal contract compliance, is very crucial. I think we all agree on that. We're really talking about, in a sense, not marginal questions, but questions about the adversity, where there are conflicts.
Well, certainly it was in the area of war powers that the president was designed to be strongest and most protected country, and I think 92% of the American people agree with that in recent weeks anyway. But the other thing about the role of the president, and it's always been curious to me why the Reagan administration and the Office of Legal Counsel didn't look at this. The basic protection against an act of the judiciary was designed not only to be impeachment, but as Hamilton said, if the court does something that it shouldn't do, the executive, meaning through the marshal's office, doesn't have to enforce it.
Well, I won't respond